Good morning. May it please the court, counsel. My name is Greg Joseph. I represent the Minnesota Voters Alliance, the Republican Party of the state of Minnesota, and several individuals dedicated to restoring integrity to Minnesota elections. And make no mistake, the state of elections in Minnesota is dire. The legislature drafted 203B-121 to ensure a fair, balanced, and uniform process to accept and reject absentee ballots. Instead, we have a piecemeal administration of elections, contradictory application of relevant statutes, and a total lack of uniformity, balance, and fairness, which is precisely the scenario the legislature sought to prevent. Unless this court remedies this situation, the practical result will be that no elections in Minnesota are fair, as they will continue to be dictated by the party in power and not by the carefully crafted statutes designed to ensure what we are asking for, which is that all elections be administered fairly. The case before the court involves two completely different approaches by two different counties, each of which turns 203B-121 inside out. The introductory clause requiring a governing body to establish a ballot board has been interpreted by Ramsey County as allowing it to choose whomever it wants, to count the votes. Ramsey County has also somehow separated the idea of establishing a ballot board from actually putting people on a ballot board. This is completely inconsistent with 203B-121 and the accompanying statutes 204B-19 through 22. This has led to a total disaster, including deputizing local staffers who are beholden to the candidates on the ballots they count, and ignoring the requirement in 204B-21 that party lists of election judges be exhausted prior to the appointment of any other ballot board members. But if Ramsey County has misapplied a portion of 203B-121, Olmsted County has completely obliterated it. They've shown no regard for party lists at all. The clear language that a ballot board must consist of election judges has been applied as meaning 0 election judges may be an appropriate and acceptable number, something both counties agree upon. The ballot board in Olmsted County is made up entirely of hand-picked staff, dubbed deputies, pursuant to unknown authority, and solely for the purpose of occupying the ballot board. These counties, by exempting deputies from the mandatory qualifications for election judges in 204B-19 through 22, have opened the door to candidates, their spouses, parents, and children making the decisions to accept or reject ballots with their own name on them. This must be stopped. The bottom line is this: Ramsey and Olmsted counties are asking you to recognize authority to appoint who they want to accept and reject ballots, and not who they're required to appoint.